I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. The Supreme Court has finally heard arguments in the much talked about VIP products versus Jack Daniels matter concerning the balancing of free speech under the First Amendment and trademark rights under the Lanham Act. That's what we'll be discussing on this installment of the briefing by the IP Law Blog. As many of you know, Jack Daniels is claiming that the Bad Spaniels dog toy made by VIP Products infringes Jack Daniels' trademarks, as it replaces key elements of Jack Daniels' whiskey bottle with dog and poop references. Perhaps what is most interesting about this case is that it requires the Supreme Court to try to figure out a test that can balance trademark rights under the Lanham Act with free speech under the First Amendment. Scott, let's tell the readers about the arguments.
Sure. Jack Daniels argues that VIP's dog toy is trademark infringement that needs to be reined in so customers don't presume the liquor company is associated with the product. The main question is whether the Rogers test should apply. The Rogers test provides First Amendment protections to works that use other third parties' trademarks on them, so long as the work is considered artistically expressive and does not explicitly mislead consumers. As you know, the Ninth Circuit had said that VIP's dog toy met that test. Josh, can you tell the listeners about the government's stance on the Rogers test?
Sure. The federal government wants to get rid of the Rogers test, calling it inconsistent with the Lanham Act. Plain and simple. But what wasn't so plain was the fact that the justices ran through various colorful scenarios with attorneys for Jack Daniels VIP Products and the government, trying to figure out what test is needed to decide whether a work is protected by free speech or infringement of a trademark, leading to a lot of laughter and some odd exchanges, especially when you think about what's generally accepted or expected in the context of a Supreme Court argument. They discussed bad advertising, drunken animals, urine sales, and dog ownership.
It was definitely a lively exchange.
Definitely. Justice Samuel Alito called it unlikely that any reasonable person would look at the dog toy and assume Jack Daniels had approved it, leading to a long back and forth encapsulating much of Wednesday's oddness. They even discussed the controversial nationwide insurance commercial, which featured a child who was revealed to be dead.
It's fascinating to see the Supreme Court discussing such odd scenarios. I can't wait to see the outcome of the case and how the court will deal with the conflicting interests. Thanks for sharing, Josh.
Of course. Thanks, Scott.
Thanks for tuning into this installment of the briefing by the IP Law Blog. Please remember to subscribe to our podcast and to our YouTube channel. And if you like what you heard or watched, please give us a 5-star review. And remember, we've got about, over 100 episodes for you to listen to or watch. And if you still would like more content like this, you can visit us at the iplawblog.com.